Vibe Talks. Vibe Talks. More than just music.
This is Nina Calirai reporting for Vibe 105. One of the biggest changes of the new year that affects all Canadians is the country's new impaired driving laws. Police across Canada are now able to demand a breathalyzer test from all drivers without needing a reasonable suspicion to do so. Police can even demand a test up to 2 hours after you've been driving. Joining me now to further discuss Canada's new impaired driving laws is Toronto-based criminal defense lawyer Joseph Neuberger. Let's talk about Canada's new impaired driving laws. What are some of the ways in which these new laws are different from the previous laws?
Well, two significant changes revolve around evidentiary standards. So the first one is if somebody is driving on one of the roads, police are able, under the Highway Traffic Act, to stop a vehicle and check for sobriety. In the past, the police would have to form some type of evidentiary basis to demand from an individual driving a car to provide a roadside breath sample. That was referred to as reasonable suspicion. So, for example, the officer could ask, have you had anything to drink tonight? If there was a positive answer about that, that could form a reasonable suspicion. If the officer detected that there was an odor of alcohol on somebody's breath, then that equally could form a basis for a reasonable suspicion to make a demand. Now, under the new legislation, an officer does not require any evidentiary standard whatsoever to make a demand. So anybody who's pulled over by a police officer can be asked to provide into a breath sample into a roadside machine without any reasonable suspicion or grounds whatsoever. That's one significant change. The second is the new laws have a provision now that if an individual stopped driving their car within a 2-hour period, the police can still demand from them a breath sample if there is a suspicion that they've been drinking, and if they blow over, they can be charged with impaired or an over 80 offense. So the significance of that is that an individual, for example, who drove home and may have had absolutely nothing to drink prior to driving, arrives home, but for some reason the police were contacted regarding this individual. The police can arrive at the person's home sometime later, let's say an hour and a half later after the call, so within the 2-hour time period. And let's say the individual got home, put on their pajamas, started to watch TV, and had a few beers or had some other alcoholic beverages, and at the time that the police arrive, they're quite inebriated. The police can demand a sample. If they blow over, they can be charged with over 80. And then, at trial, the individual has to establish 4 conditions in order to be acquitted. So the onus is shifted significantly to the person accused to establish 4 factors, the most egregious of which is that they have to hire a toxicologist who will have to establish that the pattern of drinking would have put him under the legal limit at the time of driving, and the pattern of drinking would match the what's called the BAC level from the test. It's not easy to do that because you would have to know your drinking pattern, and it's a fairly complex scientific calculation. So people, when they go home, don't necessarily measure what they're drinking. They don't necessarily pay attention to how much they're having, how they're pouring it, what cup they have in. So getting the actual pattern down to have an accurate testing can be a challenge. And so this shifts a very significant evidentiary burden to an accused, and it is ripe for somebody to be convicted, even though at the time of driving, they may have not committed an offense at all. Those are the 2 most significant changes.
You had just mentioned one of these significant changes being officers being able to demand breathalyzer tests up to 2 hours after you've been driving. How can police determine exactly when you began drinking?
Well, they would have to have some reason to see you. So let's say you're in a bar. Maybe they can walk into the bar and start questioning the patrons. Hey, when was the last time you drove? How much have you consumed here? And if they have some concerns about the person having been driving with alcohol in their system, they can demand a sample. Seems a bit absurd, but the legislation would allow it. Let's take this to another extreme. Let's say somebody leaves a function from work, and there's a coworker who can't stand them. Coworker calls into the police and says, such and such is driving drunk, even though the person may not be drunk at all. And then the police are, determine that the individual's at their home, and they arrive an hour later or an hour and a half later. Those are two significant ways that police may have a basis to seek out an individual and then demand a sample.
Yeah, I guess you had just answered my next question. So police are able to demand a breathalyzer test if you're out at a restaurant or a bar as well, correct?
Well, they have to have, again, in those situations, because you're not driving at the time, so let's say somebody's in a bar, they would have to have a reasonable basis, a reasonable suspicion, and some reasonable basis in order to demand a sample. And again, we're taking it to an extreme, because I don't see police officers right now walking into bars and questioning patrons. But because of the way the legislation is now, it's conceivable that this can happen.
When they're demanding breathalyzer tests, let's say at your home, somebody at the house is called saying that, you had been driving previously and they thought that you were maybe drinking at the time that you were driving. So a police officer comes over to do a breathalyzer test. What happens if you deny them entry to the home or you deny the breathalyzer test?
Well, first of all, if you answer the door, then the police make observations. If they make a demand and you don't comply, you can be charged with failing to provide a sample. There's very little defense available to that, if any. The person will be convicted of an impaired-related offense, will receive a 1-year driving prohibition, a $2,000 fine, and a criminal record. If you don't answer the door, then the police' only option is to get a warrant to get access to the individual, but to try and do that within such a short time frame, it would be very difficult.
And it's been said that these tests will be conducted in what are deemed as high crime areas. Do you think that in a way these tests will serve as possibly a substitute for carding? So do you see minority communities being the target of these new laws?
I always want to try and think that the police will act in a judicious, appropriate manner when following any type of criminal legislation. However, since there was a lot done to try and curb that practice, and in fact, Justice Tulloch came out with a report now. We've had amendments to the Police Services Act. The ability of a police officer randomly stop a vehicle for a sobriety check and then demand a sample allows us a fairly significant period of time for one or two officers to make visual observations of the individual, internal visual observations of the car, which could be a bridge to other searches. So it is, again, one of these type of scenarios where conceivably, if police wanted to use a stop for sobriety as a ruse, could stop individuals from identifiable groups for other ulterior purposes, such as searching for drugs or guns or other things. So it is a possibility. And it seems to me a bit of a contradiction that if Ontario legislation had gone so far, and this was notorious in Canada, to try and curb the practice of carding, that the federal government would now enact a law that would allow the police to demand without any evidentiary basis whatsoever a roadside sample, which would essentially detain a person at the roadside. They'd have to exit the car, be put into the cruiser to provide the sample. You're talking at least 10 minutes, if not more, for a stop, which could be a wealth of an opportunity for police to conduct visual observations and could be used inappropriately and as a substitute for carding. I don't want to say that that's a reality or that will happen, but it is absolutely conceivable.
And so what are your rights when it comes to these breathalyzer tests?
None. Government just got rid of it. You have no rights. They stop you. They demand a roadside. You must comply. You have no right to a lawyer. You have no right to anything other than to comply. You don't comply, you get charged. This is a very serious civil liberties intrusion, and the public knew this was happening, but only woke up to it once it was enacted and lawyers started speaking out about this legislation. It's a shame.
Mm-hmm. And last question, where can listeners go for more information on these new impaired driving laws and on your practice?
There's a lot on the internet, so you can Google new impaired driving laws, and there's a ton of information from the government. There's also articles that are out. Our own website has an article on it and other information. So our website is nrlawyers.com. People can phone us to find out information. It's 416-364-3111. But I encourage people to go to the government websites to look at it. And then if they have concerns, they should be voicing their opinions to their members of parliament as to why they're so concerned about this type of an invasion of privacy without any type of evidentiary standard and no rights for an individual at the roadside. It's really very concerning.
And unfortunately, that's all the time we have left for today. Joseph, thank you so much for speaking with me and clarifying the impact Canada's new impaired driving laws will have on its citizens.
My pleasure. Thank you very much.
And now back to your Vibe 105.